Testing 1 2. Testing 1 2. Testing 1 2. Testing 1 2. All right. What's up, everybody? Supreme Decisions here, and tonight we're going to talk about Occam's razor. Now, the reason why I bring this up is because, of course, it has to come from something that I'm doing today. Because again, I don't play law. This is actually my life. Now, most people don't know what Occam's razor is. Occam's razor is the principle that the simplest explanation, consistent with the facts, is usually the best. Now, this does show up in criminal law reasoning. Catch that. Though not as a formal doctrine, but there are several ways it's applied. Now, the reason I do this is because I think most people get caught up in their own mind or idea because they think that something is more complex than it is. And I use the KISS method. Keep it simple, stupid. And one of the greatest things that I've learned in doing this is the utmost difficult thing for an adult human to do is follow simple instructions because they believe there has to be something else. And it's amazing. Because one of the things I love, you'll hear me quote Abraham Lincoln from time to time. And what happens is, he spoke about it. Keep it so simple, even a child can understand. So I actually just give you an example. I had a case that I was working on with a gentleman, my friend of mine, whatever. And what happened was I was giving him instructions and he goes, I had to keep it so simple because he overthought everything. Everything, because I think he was a scientist or something. He had a PhD in something craziness. I don't know. I can't pinpoint exactly what it was, but he overthinks everything. So I literally sent instructions, 5 words. And he kept going, well, I don't know what to do. I handed it to my, at the time, 10-year-old son. I said, read this. So he read it. I said, what do you think I want you to do? And he repeated it. I said, now what do you think I want done? He said, isn't it that piece, that PDF at the bottom of the page? Yeah. He said, you just want me to send it here, there, and there. Yes. And I look over at him and I was like, why do you think there's more? Because a lot of times we think of things as being grandiose. We even go to the point of making ourselves more important than we really are. And this is why Occam's razor is the linchpin of winning. And I hate to say it that way, but that's why whenever I speak about how great I am, I'm not talking about anything grandiose. It's because I see the pattern, I understand the process, and I understand that at a level that it's not being taught. Because again, human nature gets in the way whenever we're talking about this. Because even when we're talking, most of us think our story is more important than the actual thing that's going on. Which is why we'll write down every detail that happened when it's not time for details. The who, what, when, why, how is how you win. And that's something you learned in 3rd grade. And you've been hearing me say, keep it simple since my first video. These things, with what, 800 plus in now? I'm saying the same thing 7 years later. And I want you to understand, simple is still winning. So the biggest part of it is Occam's theory and how it's used in criminal law. Now, the prosecution theory of a case, this is an example. Prosecutors often frame their cases using Occam's razor. The simplest explanation is the defendant committed the crime, not that an elaborate chain of coincidences happened. Now, for example, if someone is caught with stolen property minutes after a burglary, the straightforward explanation is that they were part of the burglary, not that they randomly found the items. Now, I'm going to give you an example. There was a young lady I was speaking with, I want to say about a year ago. And she was charged in an accident. Just keep it light. Now the thing was, the accident was called for a hit and run. The car that was hit had white paint scraped across it. Guess what color her car was? Her car was white. Same apartment complex. So when she drove in, there was a dent in the car in that exact same spot where the white was scraped off. So Occam's razor, she's the one who committed it. When in fact, the actual truth was she wasn't even there. And the car that actually hit the car, which they didn't find out until they watched the video, was a completely different model car. But keeping it simple, you could find a reason to believe that she did it versus some other car hit it, left, and then she drove up 20 minutes later. Because that is a story that most people can't relate to because it sounds like a lie. These are the things that most people just catch because it's readily in front of us. It's easy to understand. Because whenever you're talking to a jury, the more complex you are, you must understand that you have people that's there, that's living paycheck to paycheck. They don't want to be there. They're getting paid, 11 cents an hour? I'm exaggerating, but it ain't minimum wage. And they're just sitting there, and then they're listening to you, and they believe you're guilty, and you're the reason they're there, so they're upset with you. So you have to give them a story that they can relate to, which is why the prosecution cannot win in most cases. The defense has to slip up. If you lose in court and you lose with a jury, it's because you didn't convince them that you were good. And you probably did what most people do. You relied on human nature and made the story more elaborate than necessary. Now, give you another example. Possession of stolen goods. Ladies and gentlemen, the defendant was found with the victim's jewelry in his backpack 2 hours after the burglary. The defense wants you to believe that he just found it on the street, which makes more sense. That he committed the burglary or that he stumbled across a bag of jewelry left on the sidewalk. The simpler explanation is the truth. He's guilty. Now, understand the relatability part of it. It's more elaborate that he happened to find someone's jewelry on the street that had just of a house that just been burglarized versus him being the burglar. Now, again, those are things that the prosecution do. Even with the murder in circumstantial evidence, because this is what they do in these type of cases, because I'm actually do a series, a little short series, called Supreme Decisions, How to Get Away with Murder. Because most people overestimate the ideas of the prosecution versus knowing exactly what to challenge. And I'm going to keep it simple because there are certain ideologies that just can't be explained. And these are the ways that you can actually get away with murder. even in today's time. Now, the prosecutor, a defendant's fingerprints are on the murder weapon. He argued with the victim the night before. His phone pinged near the crime area. The defense wants you to accept a series of wild coincidences. The straightforward explanation is that the only one that fits all the facts is that he's the killer. Always understand, they keep it simple because the simplicity is what relates to the jury. Because remember when I told you, again, I think it was video number 11. I'm not teaching you this so you can regurgitate law. I'm teaching you how to practice this in a courtroom. This is what I want you to understand. So you have to understand the ideology of not only the prosecutor and their tactics, but you have to understand the mindset of those people that are sitting there that you're accepting judgment from. Notice the words I just, I want you to pay attention there. Now, here's the flip side of that. Because defense attorneys sometimes push back against overcomplications in prosecutorial theories because, again, they are designed to do that because this is an adversarial system. Now, you yourself, if you're defending you in this, the state is asking you to believe in an overly complex chain of assumptions. Now, this is when they're using evidence that's circumstantial. And I'm going to throw in a key because this is one of those for free for you. Never use the state. Know your opponent. When you're speaking to the jury, use their name. One of the biggest things you need to do when you're actually in front of them, give them someone else to be upset with because they're coming in, they're upset with you because you're the reason they're there. And just like I did in my case, I learned this early. I never said the word the state. I pointed over there at the table, John Melvin. John Melvin said, John Melvin did. John Melvin. And I forgot the other lady's name. Officer Johnson. Lydia something. I used everybody's name because I wanted to make sure the jury was upset with whoever. I used the witness' entire name. Whoever the witness was. It's Sergeant Charles Johnson. Sergeant Johnson. Because I think one of them came up there in uniform, so I referred to him by Sergeant or whatever his ranking was. But you want to give them someone to be upset with. And the one that came up in uniform was Johnson. And I actually got him to admit to lying on 4 separate occasions. So that I didn't have to call him a liar. He showed that he was lying because he admitted to lying. So therefore, it took away the ideology of the badge, and it also tainted anything they did afterwards because I humanized him. Because remember, in most of our ideology of police officers, they're not human. They're something else because they're supposed to be pedestalized. I allowed him to step off that pedestal. And once that happened, everything else became easy because you can hate someone that you believe is human. Always understand that. Don't use the state. Say, Steve Johnson is asking you to believe an overly complex chain of assumptions. The simplest explanation is that my client is innocent and the evidence is flawed. Now, one of the techniques I used was a catch and release. That's when you don't allow the judge to rule on an objection. Because I did exactly what he did in my closing. I stated, I don't want you guys to hold John Melvin and company to the state of make-believe because this is not CSI. And he yelled out objection. And before she could rule, I said, My Honor, I'm just asking the jury to do exactly what John Melvin asked them to do at the beginning of this. Don't look at this as a state of make-believe. Do not hold them to the standard of CSI. And I kept going on with my closing. I never allowed her to rule. Now, that does a couple of things. I'll explain that later. But when I did that, it also showed I had control. Don't hold them to the standard of make-believe. Why? Because that's exactly what this is. And then I referred to the fact that you never heard anybody come on this stand to say I actually broke the law, and you won't read it in this evidence book. And I went and picked up this heavy-ass book. It wasn't even an evidence book, but it was just a heavy-ass book that they had sitting on the side because they were using it as a prop. But what that did, that stuck in their head, because why do we have all of that? And now I have them thinking about everybody's testimony. I had them thinking about the liar that they had on the stand. I had them thinking about the young lady who called me an N-word over the phone and admitted to it. We also talked about different aspects of it. But again, I kept it simple. Why? Because I made them not only pay attention to me, I made them think about everything he said by keeping it simple. I didn't try to make him a bad person intentionally. At least it was not obvious. I kept it simple. Do exactly what he said do. So it looked like we were in agreement. Always understand, keeping it simple, you don't have to badger anyone to make them look bad. They'll do that themselves. But even in these contexts, keeping it simple, for instance, if the only evidence is shaky eyewitness testimony, the defense may argue that mistaken identity is much simpler explanation than the defendant orchestrated a complex crime. Always understand, keeping everything simple is the means in which you want to go through and get everything done. Because even if it's eyewitness, the state asks you to believe that my client wore a disguise, switched cars, and somehow left no DNA behind, yet left his face perfectly visible to a single eyewitness, or the simple explanation, the witness made a mistake. Mistaken IDs are common. Simplicity favors innocent. And even in drug possession cases, these are my great ones here. Police found drugs in the car where 3 people were seated. The state says it belongs to my client, but there are no fingerprints, no DNA, and no confession. The simple explanation, it could have belonged to anyone in the car, and the state hasn't proved otherwise beyond a reasonable doubt. Now, here's the next part of that. Let's say you've already had a police officer up there. It is not out of the realm if you put together a strategy, or let's say there's a dirty cop that has mishandled evidence prior. Those are different chains that you can attack because, again, even in those, they have to have an explanation for the things they've done. Even in those explanations, most people can spot bullshit. And that's exactly what you do. But you want to make sure everything you do is line by line, precept upon precept, and you keeping it simple. Because you don't want complexity. Even if you have an expert witness, these are things that need to be discussed, and you have to understand how to use them, because you don't want someone that is I call it mechanical, because even in their mechanical beings or methods, you can confuse the jury, and then they would be more upset with you. So that's also one of those things in which you want to make sure you keep light. But you also want to make sure every move that you make is precise and calculated, and that you don't throw something out there just because. Now, appellate court use simplicity. Appellate courts sometimes apply Occam's razor for reasoning explicitly in eyewitness reliable appeals. Judge notes that more reasonable and straightforward influence is that the witness misidentified the suspect when other evidence is missing. When you're reliant 100% on someone else's vision or recall, which we know can always be skewed, these are things in which you can challenge always. In probable cause challenges, courts often hold that the simplest reading of the officer's observation justifies or undermines the stop and search. Remember, the reliance from the officer is what either going to justify or undermine the case, which is why you go and put the officer's character on trial. Now, why this matters? Because lawyers can make jurors feel comfortable by reducing complexity. That's the key. Keep it simple. Human psychology favors the simplest explanation that feels complete. Prosecutors use it to paint defendants as guilty. Defense attorneys use it to dismantle overcomplicated theories and push for reasonable doubt. Now, even when we're talking about going through that portion of it, it's always the key is to take apart the prosecution case without. Here's the thing. I'll use this theory because a guy told me this in Chicago. Old ass attorney in Chicago told me this one day. He said, no one cares about defense. You talk last, and the prosecutor talks first and talks the longest. That long-windedness is what irritates the jury. Allow them to be irritating because you want them in your favor. And the longer the prosecution keeps them, the more that jury swings to you, regardless of what's being said. But you have to do things that are either calculated or time related. Because when you get up, say things. I actually got him. He actually told me say things like, "I'm not going to hold you long because we've been here all day." Why? Because that sticks in the juror's head. Yeah, the prosecutors had this dude up here for 4 hours. The defense attorney was up here for 2 minutes. And believe it or not, little things like that actually goes back into that juror's room. Because he's like, hold on, why do you have him do all that talk? Oh, he must be hiding something. Because he just came up here and asked 2 questions and sat down. Keeping it simple makes an impression on the jury. Because there's a time and place for details. And if you put it in a strategy in the wrong place, you could be showing your hand too soon and then offer them an opportunity to beat you. Always know that. Now, in police interrogations, detectives naturally used Occam's razor mindset. They look for the most straightforward suspect or motive before chasing exotic theories. The reason is because they are not taught how to solve crimes, because they don't hire people that are thinkers. I'm going to say that one more time. They don't hire people that are thinkers. They are not taught how to solve a crime because they are not people that you will see putting together a puzzle, which is why they're wrong 2 out of every 3 arrests they make. Yes, I said that. They're wrong 2 out of every 3 arrests that are made. But criminal law recognizes that this leads to tunnel vision. Sometimes the simplest explanation is not the correct one, i.e., wrongful convictions based on simple but false assumptions. Because even in Terry v. Ohio, the words hunch, police officers are not allowed to use a hunch. before making an arrest or even a stop. Most cops don't even pay attention to that. And they'll go, well, you got to follow your instincts. Well, instincts is not police work. And it is actually illegal. Yes, I paused for dramatic effect, and plus I'm going to get me a little sip of water. Now, going back to the jury real quick. Jury instructions and the burden of proof. Juries often use Occam's razors informally when deciding between two competing narratives, which adversarial system, prosecutor, defense. The simpler, more consistent one tends to feel more credible. You don't need an over elaborate, overtold story. Understand that human nature. Do you just want to be sitting somewhere listening to somebody's bullshit for hours? No. Especially when I could have been at work. Those would be days where like I could put up with Brenda's stuff today. I just sit down there and just do my job. I wish I was working. And then you start thinking about the bills you got at the house because you're sitting here because this idiot won a jury trial and he know he's guilty. And all these people, you have to change their mind because now little seeds are being planted throughout. Now, however, the law requires proof beyond a reasonable doubt, not just a simpler story. So Occam's razor can't override constitutional standards. However, sometimes it does because you have a smart defense attorney that understands how to, as they put it, work a jury. Because it's putting together a strategy that is simple and the most effective. Now, if they have to go into their bag and pull out some tricks, you got a complicated case and it can get crazy. So just understand that. Now, the appellate reasoning. Appellate courts sometimes favor simpler interpretations of evidence or law when reviewing trial errors. This is what I see most people mess up on when they're doing appeals. They're giving too much information and they're not getting directly to the point. Keeping it simple is what gets everybody in where they're trying to go to. Now, here's one point that I actually like. The simple fact that you have a theory. Let's say you lose your case, you're filing an appeal. Well, appeal will tell you we are looking for 1, 2, 3, and 4. And whatever your case or whatever part of your case falls under 1, 2, 3, and 4, that's all we want. However, we'll write a 20-page transcript forgetting that the law of human nature is less than 1% of people that graduate high school, ever read a book again, and that number is dropping. That also includes doctors and lawyers and judges, the ones who are making decisions. I've been told by several judges, if something is more than 8 pages, they don't even read it, they just skim it. So the max they're going to actually read is 8 pages. That's why when you look at these large law firms, they have 5 lawyers and 400 paralegals. That's what you're looking at because somebody else is doing all the reading and research. They're just skimming. Just like I tell a lot of people, I don't go through and read each and every document you send me because I'm looking for keywords. Boom, that's what I'm looking. Why? Because the nature of the beast doesn't change and I know what I'm looking for. This is why you have to be cognizant of what you're writing, when you're writing it, the verbiage you're using when you are writing it, because all words have a purpose. Words retain their meaning, even if you want to use Ebonics. The problem is they're not speaking Ebonics in the courtroom. Guess what you're not going to do? Win. You have to speak the language of the court when you're attempting to go into their world and beat them. Because if you use their rules, they don't know them and they don't follow them. And when they don't, you can hold them liable for it, which is why I'm constantly talking about this. Now, Occam's razor isn't a legal rule in criminal law, but it's a persuasive reasoning tool. Say that one more time. Occam's razor isn't a legal rule in criminal law, but it's a persuasive reasoning tool. Remember, I told you, law is a tool. The application of it is how you work it and frame your dreams. Used by police officers, lawyers, and jurors alike to preface the most straightforward explanation of events. So as long as it fits in the facts, that is the burden of proof. Always keep in mind that the people that you're standing in front of, you're being judged by 12 instead of carried by 6. These are the ones that are making a determination, and you must understand their mindset as well. Keep it simple. And don't forget, you can donate to the channel. Let's keep going. Let's keep growing. You can also join the channel. We got several different levels. Contact me via email if you need me. And also, you can set up a what do you call that? A consultation by clicking the link in the description. And Supreme, I'm out. I think I am anyway.